at noon o'clock.
Excellent.
So we give just like a couple minute or two for folks to log on, and then we'll get started. And I think, as always, please ask your questions in the Q&A for us as we're going through the materials. No need to hold them till the end. And if it's something we're going to cover later, definitely can let folks know that. But, please, this is a complicated area of the law, and there are not a lot of like black and white answers when it comes to these kinds of questions. There's lots of shades of gray. There's lots of it depends. They're very factually specific, depending on the building, depending on what the ask is, depending on what your housing model is or your management model is. And so there is not a lot of one size fits all responses for this area, which I think is one of the things that creates a lot of challenges. So.
And Angela, I'm going to do something I don't think you've ever seen me do. I'm going to start off today with an apology. I'd like to apologize to one of our attendees, Dora Dernovich, who left me a message on Wednesday about a landlord question. Dora, you were on the short list. It's been a crazy couple days. My apologies. Hopefully you'll forgive me. But with that being said, I'd love to welcome everybody here. We're going to get going in just another minute. As you guys probably know, have the very talented, intelligent Angela Zakowski from the Vermont Apartment Landlords Association. Truly one of the best investments you can make if you're a real estate investor is joining this association, be it the guidelines, be it the assistance with background checks, be it, forms and advocacy. I think one of the things we forget when we hear all these challenging regulations coming in is how important it is to have advocates. My name is Brian Armstrong, CEO of Keller Williams, as well as I'm part owner of Strongwell Property Management and the Strongwell Real Estate Team. Angela, two things come to mind. One, yes. We do this every year, the yes. Fair Housing Month, and I hope this doesn't, upset people. Every now and then I was like, all right, and again, but what you just touched on was huge. Doing this every year to refine how we can be better providers, more compliant providers, and navigate things in a way that let us balance competing interests, being good yep. community citizens, while also we're not running our buildings for charity.
Right.
I'll start off the second piece, and then you can tell me to cork it, or you've got controls, you can mute me. You've used them before. I'm not going to hesitate or have you hesitate to use them again. When I think of fair housing, I think of, and I'll tell a quick 30-second story. I think of a very individual that came to us, one of the apartment buildings I owned. This is going back 10, 15 years. Angela's heard a little bit. Super well-spoken, super polite, physically challenged. I had a ramp that hadn't been used in years. Wanted to do the right thing. My mother raised me right. We moved her in without checking references, without Googling. We started to have some challenges. I Googled the person. I found out they had an 11-page handwritten deposition in the U.S. District Court of Arizona stating that Radio Shack and Sprint had stolen contacts out of their phone and were harassing the people. Now, if I had Googled them and found that, I would have never rented to the person. But one of the better things that I did, and I didn't do everything perfectly, we're all human, was I preemptively brought in the city of Winooski, who brought in the state, to go through and take a look at what could I do to make sure this building was up to code, had reasonable accommodations, was safe for this habitant for two reasons. One is they may or may not have been challenging, but they deserve that place to live. The second thing is I wanted to make sure that not only was I a responsible housing provider, but the state and the city knew I was approaching this to be proactive. So that being said, Angela, take us away on an extremely important topic.
So fair housing, this is going to be sort of a nuts and bolts fair housing again. We're going to talk a little bit about what fair housing is, sort of go over what the standard protected classes are for both federal and state. So I think that's one of the intersects here that is create some challenges, is that there is both a federal framework for fair housing and a state framework for fair housing. And those two sometimes overlap, sometimes they don't overlap. But in terms of trying to change fair housing requirements, a lot of the rules and processes that we have to follow have come down because of the federal act, not necessarily because of the state act. So with those two layers, it's a lot more complicated if we're talking about changes or implementing change to the law, because it's not just at the local level. So I think that's something worth keeping in mind. We're going to talk a little bit about reasonable accommodations, specifically as they relate to emotional support animals, because that is still a really sort of hot topic for folks. We're going to talk a little more about the Violence Against Women Act, because that does have a fair housing component to it. And then again, questions for that. I almost for this seminar put together something related to inclusive language, because I think that's the next thing coming down the pipeline that landlords are going to have to deal with. I will be the first to admit that I'm not remotely an expert in that field at all. And I'd prefer to find somebody that maybe had a more training and more experience to present that to the group. So just,
Sense.
keep an eye out for that. I think we might try to bring that in. I think there are some challenges that landlords are going to learn have to learn how to navigate on that particular topic. Um, all right, so let's jump right in, and hopefully nothing is covered on my screen with some of these windows that are popped up. So what is fair housing? Sort of in its essence, it's a person's right to choose where they live, either if they're renting or if they're buying, and to be able to do that free of discrimination. So that, seems pretty straightforward, seems pretty rational, one of those things that like, well, of course, that's that's what, we want to do and what we want to strive for. But I think, history unfortunately has shown us over and over again that this is not actually the shake or the situation that many people find themselves in. So really, we're talking about equal opportunity to housing, so that everybody has the same opportunities, that they aren't being steered one way or the other based on characteristics or perceived characteristics, that decisions aren't being made for them by other people based on what that person, either the realtor or housing provider, believes would work well for the other person. So, the thing to remember with fair housing is it's the person who's applying for the housing, it's their job to decide if a unit is going to work for them or not. And your job as a housing provider is to show them that unit, to give them an application, to give them information about the unit itself. But ultimately, it's that person's decision if that unit's going to work, but occupancy standards or other things aside, but in its essence. And so this next slide, again, what is housing discrimination? These are all categories of things that I pulled directly from the Vermont statute, right? So remember, we have this federal statute and we have Vermont statute. So these are all things that come directly from the Vermont law. So refusal to rent. That's just a plain old, not going to rent you this unit because, or tends to be a lot more subtle. I'm not going to rent you this unit. You leave off the because, but there is a because. Setting different terms. So, this can come up a lot of times if people have children. Landlords want to protect, their investment. They want to protect the children. Again, same terms. You can't have special terms for people because they fall into a protected class or something like that. This, comes up with things like rules around pools or sometimes quiet hours. You can have rules that are neutral and apply to everybody, but make sure you're not have a different set of rules for people if they have kids or if they fall into a protected class. This one, to make, print, or publish notices that indicate a preference. So this would be for advertising purposes. So this is sort of that typical, you can't have an advertisement that says unit perfect for a couple, or quiet professional, or, something that is describing a person or who you might want to rent to. So advertisements like that indicate a preference, and would discourage people who maybe don't fit within those categories or classifications from applying. And that is a form of discrimination.
Angela, am I also
Yeah,
correct and tell me if it's fair housing or ADA both? We should be things like easy, be careful of easy walk to, downtown. Because to me, my guess is most of our people on here today, which is always great to have you on, are probably some aware of the super obvious ones. Great for family, great for, stuff like that, family,
right,
neighborhood, all that stuff. But the easy walk, stuff like that may
right.
not be as obvious. And
Right, right. And there's some, newer things that are evolving with that, right? So yes, I would agree. Like you have to really, um, I think focus less on those sort of descriptors and more on the unit itself. How many bedrooms? What's the square footage? What amenities are included? What the location is, but without any descriptors, because really it's on the person who's seeking the housing to investigate the neighborhood, or if they ask you, that's a little bit different. But to just advertise those things, yes, it can start to walk up to that fair housing line or cross it. And I think one of the challenges right now is how people advertise, right? So once upon a time, you used to put an advertisement into a newspaper or an online news publication, and those advertising editors also were looking at your ads, and they were also looking at them for fair housing, because a few of them got into trouble themselves for having ads running that violated fair housing. Uh, but now with, sort of self-published websites, places like Zillow and some of these others where there's not sort of a editorial or advertising person who's looking or reviewing at these ads, it can be very easy to inadvertently create something that has some fair housing violations, and there's not another layer of people looking at it to say, no, you have to change this. So something to just to be aware of. Um, so it is housing discrimination to falsely represent that a unit is available, right? So this is the old, I don't want to rent to this person. I don't know what else to tell them. So I'm just going to tell them the unit's not available or that the unit's already been rented. And if that's not true, that could actually be a fair housing violation. So just, be careful. If you're processing applications or you have other applicants in the wings that you have offered the unit to, that's different. But just make sure what you're telling people is accurate and true.
I might say, and again, you can mute me if I start oversharing, the importance of doing for one what we do for all. So if
Right.
you're super busy, you're like, hey, Angela, I'll show it to you. And then the next person, you're like, hey, look at all the photos, do all this, only then will I show you the unit.
Yep.
Even if that's because when Angela, I talked hypothetically, I was wide open and I was slammed the next time. I think there's an importance of, I hate to say it, creating models and systems in our conduct,
Yep.
evidence our support and respect of these rules and regulations, and not unintendedly become an example of the road to hell is paved with good intentions.
Right. I mean, there's some landlords and housing providers who have gone to like a virtual tour model. So they don't actually do in-person showings. They have all of their units have been captured digitally for a virtual tour. And that is what's available to folks to look at. They can do it on their own time. They can see the unit without somebody's stuff in it. If you haven't seen a virtual tour, if they're done well, they are like standing right there in the
Mhm.
space. You can move around, you can see everything, you can walk over to places. They're quite impressive actually, and can be a really good tool. Um, some of them are sophisticated enough that they provide square footage. They, can provide dimensions. So they're pretty good tools. Some of the landlords have gone to them, I think, out of partially safety concerns, but also from a time management standpoint. So they're not wasting time showing units to folks or setting up showings and disturbing the current tenants. So, that's one of the things that came out of sort of the COVID times,
Mhm.
and many people have just stuck with that process because it seems to work well for folks. But again, that's, systems and processes, if you have things like that, that allows you to share the same information with everybody, regardless sort of how busy you are or what else you have going on. But Brian's right. A situation like that could get you in trouble for a fair housing violation, even though there's a perfectly reasonable explanation for it. If you've treated people differently, that can create some issues for you. So again, denying access to a facility. So this is like denying a showing. Again, that's that, sorry, I can't show it to you. Um, and inevitably it's going to be the person who fits into a protected class that just, it's always, of course, it wasn't the, this person didn't reach out when I had lots of time. They reached out when I was busy, and, life gets in the way. But it's still, if there's that denial or refusal to show, you could end up sort of on the receiving end of a fair housing complaint. This one, I would say I don't see that one happening here in Vermont. The coercing, intimidating, threatening, I'm sure it does. But I've seen really egregious cases under this category in other places. So the federal statute is very similar to the Vermont statute with the categories. But this coercing, intimidating, threatening, there's some pretty over the top stuff that folks have done, housing providers have done, or property managers have done in other places, which is why this is in here and why this has become a part of the law. So, it's the folks doing what they're not supposed to that create more regulations for the entire population to navigate. So
I would argue, I heard a quote once that said, the haste to attain victory is the surest way to not be victorious. And I would argue in our case, the haste to get somebody out is probably the surest way to actually make it take longer, with the
right,
exception of a potential, worked out buyout agreement. Yeah,
right,
no,
right.
probably most of us know how frustrating it is to have a challenging resident in, but that's
Yeah.
also probably means it's time to step back, call you, and
Yeah.
think logically as opposed to emotionally.
Right. And I think, stepping away from fair housing for a little bit, when I look at all of our large landlord tenant regulations that are in place, retaliation, habitability, some of those larger regulatory frameworks, and the date at which they were enacted, for every single one of those, you can go back and you can find the Vermont Supreme Court case that dealt with whatever that issue was, with a fact pattern that I think all of the people on this webinar would say, I can't believe somebody did that. And so, you see that bad actor, and then on the heels of that, regulations that impact everybody. So, those two tend to be related. All right, so this is sort of a general rundown of the various protected classes. We have a group that are federal, and then we have a group that Vermont has added. The federal are sort of the standard ones, race, color, national origin, religion, sex. I will point out that there was a recent US Supreme Court case that made it clear that sex discrimination at the federal level includes gender identity and sexual orientation. So prior to that Supreme Court case, Vermont had them covered because Vermont has them listed out in their list. But now those two categories are covered under the federal law as well. So it's very clear that that's part of sex discrimination at the federal level, which is relatively new. We also have familial status, so that's presence of minor children. There could be someone who's pregnant. It could be people who are looking to adopt or foster. We have disability at the federal level. And then Vermont has sort of added its own set of categories. So age, marital status, sexual orientation, and gender identity, but those are now covered at the federal level as well. Receipt of public assistance, and then victim of domestic violence. So those are all categories that are further covered under the Vermont Fair Housing law.
Angela, we can stop there for a second.
Yeah.
A thought, a tip, and then a question for you. When I was more actively involved in leasing out our units for the property management as well as my own buildings, and I would get the question of, do you accept public assistance? I'd say something to the effect of, we consider all applicants equally, irregardless of the source of income, based upon their references and credit.
Yep.
And because I've seen, probably as people on here would agree, some cases that you're like, wow, that person's fleecing the system. I've also seen cases where I am so glad that system is in place. So that helped me really look at the quality of the individual, not necessarily source. Now, the question I have for you is, and I'm sure I'm going to get part of this wrong, what about when somebody lives in, I think it's 4 units or less, and they live in the property? Don't they have a little bit more?
The Mrs. Murphy's exemption.
Mrs. Murphy's exemption.
Mrs. Murphy's exemption. So there's one in the federal and there is one in the state. The challenge with those exemptions is that it doesn't apply to the statements clause of the fair housing laws. So it's one of those things where you can think it and you can use it, but you can't say that that's what you did. So effectively, it doesn't really exist to some extent. So yes, if you're an owner occupied and you have three units or less, you can be a little bit more choosy with who you're renting to, but you still have to be careful because it's not the fail safe that it's been made out to be in some forums.
Thank you.
Yep. All right. So everybody's favorite, reasonable accommodation. So this is the area of fair housing where your emotional support animal requests could come in at. So what is a reasonable accommodation? So reasonable accommodation is a change to a rule, policy, or practice that allows a disabled occupant the opportunity to use your dwelling unit. So this reasonable accommodations is only applies to folks with a disability. So I think that's an important piece to remember. It doesn't apply to everybody. And it is really only for sort of those feasible and practical policy changes. But it's going to apply to a large number of things. Like where we see this come up most are no pets policies and a lot of times parking and parking related issues. Those are sort of the 2 big ones that I see. There's definitely others, but those are generally the most common. There is sort of this little catch-all that says if whatever the request is fundamentally alters your business or is unduly financially burdensome, you may not have to request or grant the request. But what I will say is you have obligations under the law to have sort of this back and forth conversation with the person who's requesting the change. And my guess is most of the time you're going to be able to find something that's going to work for you and your business practices. And that is also an accommodation for that particular person with what they're requesting. So, if their first sort of request out of the gate is, I need X, Y, and Z, and you're like, well, I can't do X, Y, and Z. It's not a no, and then the conversation stops. It's I'm not sure I can accommodate X, Y, and Z, but let's chat a little bit more and find out if there's something that we can do to help or to make a change. So it's sort of this back and forth situation that needs to happen with these types of requests.
And I would encourage anybody who's dealing with these, not only to potentially get, ask Angela or ask if she's got a contact that can help you make the answer, but step back and ponder it. So give me an example, Angela. We've got, I know, a couple of real estate agents that are either on here or join us on a regular basis. I had a situation yesterday where an advocate for a tenant who said their children had special needs, that all showings happen in the morning. And the challenge I saw was you got to coordinate access for the buyers, their agents. The seller's got a right to optimize the value of the property. And if you said showings only from 8 to 10, I don't know how many buyers would be able to make that window. And and then I sort of caught myself getting frustrated. And I answered it with questions, but as I step back, to me, I think that would be a good example of making reasonable accommodations. Maybe it's not only mornings, but showing that we made an evidence to do morning showings or even open windows to do it. Basically saying how there's a conflict here at times with, you said, competing interests.
Right.
Rights to the tenant, rights to a person to make needs reasonable accommodations, and then obviously a right to conduct business. And if a seller is selling a building, that's making it reasonably easy to show, which can be
Right.
a challenge in certain instances.
Right. Right. Well, if that building owner had a virtual tour done of their units, they could accomplish some level of a showing
Spot on.
without having to disturb those particular tenants. So I just throw that out there again.
And I think we have a question from the audience. Dora, I believe, has a question. Hang on a second. And Dora, you're more than likely, if you want to write that in the Q&A, we'd be happy to answer that for you.
All right. So I think one of the biggest areas where we see reasonable accommodation requests is as it relates to emotional support animals. So somebody who has a physical, mental, or emotional disability can request a modification of a no pets policy, which would allow them to have an assistance animal that helps alleviate some symptom of their disability. So this is an area where no special training is required for this animal. This is what we refer to as an emotional support animal. It can be made at any time. There's no requirement that it is made when somebody's at the time they're renting. So that can get incredibly frustrating for landlords. But just, you can be in the middle of an eviction with somebody for having an unauthorized dog, and they can make the request that this is an emotional support animal. So this is how sort of strict, I guess, for lack of a better word, this area of the law is for landlords. So, and if that support animal is approved, it is an exception to your no pets policy. So it's that, change in practice or rule. It does not have to be a specific type of animal. So this also can get really interesting depending on what type of animal is being requested for an emotional support animal. And it doesn't have to be specifically trained. I have for the last sort of few years posed the question to landlords as to whether or not it made sense to start reevaluating their no pets policies. Because the other thing that comes into play with emotional support animals is you're not allowed to charge an extra deposit for that animal. You're not allowed to charge extra rent for that animal. So that animal comes in with no sort of financial protections for the landlord. Can you hold the tenant responsible for damage? Yes, but you don't have that upfront extra financial protection. So, I've been, again, posing the question, is it time to reevaluate for landlords having no pets policies? If you allow pets, you can charge pet deposits, you can charge pet rent, you have some other ways to protect yourself. Interestingly enough, I was talking to a landlord a couple weeks ago who just opened a new building, and they decided to make their new building pet friendly. And out of the 2 or 3 dozen units that were in that building, they have had one ESA request for the entire building. So, they still were getting those requests, but their experience was in a building of that size that had a no pets policy, they would probably have at least half a dozen or so ESA requests for the building.
If I may, I want to make sure I heard something. Did you say that if it's not associated with an ESA request,
Mm-hmm.
Can we charge extra deposits for pets?
Yes.
That's awesome. I thought it was
Yes.
potentially the contrary. And did I
No.
also hear? I've grown today. I'm going to recommend to Dan we start doing more virtual tours. We generally are relatively flexible, at least in the buildings I own with pets. But did you also say pet rent?
Yes. Some places that allow pets charge a monthly pet rent. So it's a per animal charge on top of
Yep.
regular rent for those. And what that pet rent is then non-refundable, right? So it's a payment that again sort of goes to the wear and tear and the potential damage that could happen, but it's not refundable at the end of the tenancy. So, yep.
Yeah,
And
when I was more actively involved in leasing, I actually found by being pet friendly, we got some great applicants
mhm.
because there were so many buildings that weren't. Now, and I'm not, and you can tell me if this is out of line. I think it's in line, but I would encourage people, hey, if you want to, if you're considering have a dog, please bring the dog with a showing. And I joke with them, if it's loyal to the next peanut butter sandwich, we're probably going to be fine. But if it's trying to rip my hand off, it's probably not going to work.
Right.
Um,
And you still can vet even an emotional support animal, you still can vet them like that. And and if, an animal is displaying aggressive or not appropriate behavior, you can say no, right? You have to have a reason though. It can't just be like, oh, no, I don't like this breed of dog, or, it has to be tied to the specific behavior of that animal. The Landlords Association has a pet addendum and then we have a support animal addendum, and they are exactly the same in terms of behavior of the animal and expectations of the behavior of that animal. It's just the support animal addendum doesn't have a spot for a deposit. Uh, but you can't, this isn't a free for all. Like if a support animal comes in, it's not just like that animal can behave in any way and the owner just has to accept it. You can have, reasonable guidelines in place regarding behavior and not barking and being under the control of the owner and picking up waste and things like that. And you can successfully evict people for violating those rules, even if it's an emotional support animal.
Excellent point. We've got two great questions. Thank you, Dora and Sandy. And as a side note, with dogs, I would also encourage you to check with your insurance company.
Mm-hmm.
One time I had an applicant show up, said they had a Doberman, and I've met plenty of great Dobermans, been some challenging ones as well. And I encouraged them to bring in the showing, and they didn't. And then I asked my insurance company, the insurance company said, ask for verification. It'll be okay if they can, we'll insure you if they can provide verification or a statement the dog's never bitten anybody.
Right. So,
Side
so,
note,
right. So as I
go
say,
ahead.
so there is that. Many insurance companies have moved away from a banned breeds list. There are still a few that have them. But if you are running up against that with your insurance company, I would make sure they know, and I would do it in writing, that the request that's coming in for a particular animal is for an emotional support animal. And then if they still deny and say no, make sure you get that in writing from your insurance company, because that becomes one of those undue burdens that was on that earlier slide. But you need to do a little bit more due diligence, right? The insurance company needs to know it's an ESA request. And then if they still say no, have that in writing, keep it in writing, and that can become a basis for saying, no, I can't allow this particular breed. We'll approve you for an ESA. We can't allow this particular breed because our insurance company has said no. But if it's a different type of animal, the answer is yes. So, but you have to have that documentation. You have to take those extra steps.
Great point. All right, so we have a question, Dora. Thank you very much. Different question I had for you previously, Brian, or yesterday, Brian. Had a situation recently. We think we handled it well, but you can let us know. I'm sort of paraphrasing a little bit. We had a tenant reach out who said they were physically disabled and with a live-in caregiver
Mhm.
and a dog. They asked if we accepted Section 8 from Barry Housing Authority. I responded to say we welcome all to look and apply. At that time, the home was not very accessible currently, and
Right.
listed the reasons, such as many stairs to get inside, tub not shower, average size of the doors, hallways, etc. I said we had not looked into Section 8, but would consider that, and asked if their dog was a pet or assistance dog, and we considered pets on a case by case basis. Ended by asking if they're still interested and would like to schedule a showing. Never heard back. Almost sounded like a test.
And it could have been, right? So we know that there are testers out there who respond to advertisements to see if they get different information. Um, I think as long as the description of the property is something that you would provide to anybody, again, so it's not, one spiel or
Mm-hmm.
one description for somebody who's indicated they're disabled and something different for someone else. It's that level of consistency with the information that you're providing.
Mm-hmm.
So, I think as long as you're providing those same details to everybody who's making inquiries regarding the physical, the stairs and, the layouts of things, then it's probably, I'm not going to say you're totally fine, because that's not a very,
Attorney-ish thing to say.
yeah, that would come back to bite me. But that's the best, that's what you can do. It's just make sure you're responding the same to everybody, providing the same information, offering to show the unit. I think your comments about Section 8 were fine and appropriate. So that's would be my 2 cents.
Excellent statement, possibly question from Sandy. Thank you very much, Sandy. It was my belief that service animals were in a different category than emotional support animals. You had to take service animals, but not ESAs in Vermont.
So service animals are a class of animals that are allowed in places of public accommodation. So it's a completely different area of the law, and it applies to different points of access. So places of public accommodations are things like retail stores, restaurants, hotels, shopping centers, like things out in the public purview. And in those areas, the only animals that are supposed to be allowed are service animals. And so service animals are specifically trained animals. They are only dogs or miniature ponies. They're specifically trained to do tasks and perform tasks. And that's a different area of the law than housing. So housing is ESAs. It's much broader. It's much more relaxed. And it is a different set of rules than for restaurants and retail establishments.
Sandy, thank you very much.
All right. So if somebody is asking you about having an emotional support animal, the things that you are able to ask are relatively limited, but they still will give you sort of the information that you need to know. So you can ask for verification that the person has a disability, not what the disability is, but that they have a disability, but only if the disability is not obvious. So if somebody comes in a wheelchair, you can't be like, well, I need verification that you have a disability, right? So it's only if it's something you can't see. You have the right to ask what the accommodation is that they're requesting. So for an ESA would be, I'd like this animal. And then sort of what the connection is between the disability and that accommodation. What you're going to see is most people, when they're making these requests, are going to come to you with a letter from a healthcare provider of some sort, generally, whether it's a doctor, nurse practitioner, mental health counselor, could be a social worker, that sort of lays this out, right? These folks who work with people with disabilities are very well versed in what the rules are, what the requirements are. So you're going to see a letter that is like, I work with Michael Smith. He is a person with a disability. It would be very helpful for his treatment and his symptoms if he is allowed to have a dog. Like that, you're going to see something along those lines. Does it have to be those specific words? No, but those are the kinds of things that you're going to see in a letter from a healthcare provider. And that is going to meet the standard under the law. So some things you can't ask. You can't ask what the disability is. So it's enough that somebody just says there is a disability. Questions that would require medical history to be disclosed, and whether or not the person can live independently. So those, again, are things that are not part of the analysis when you're looking or having a request that comes in for a support animal.
So, as far as the care providers, because I've had those requests before,
Yeah.
what what thoughts or questions can you give us that we can answer about the care provider? Because it's one thing we
Yep.
screen the tenants, but when we're
Yep.
talking about a live-in care provider, yes, they may change, but they're going to be there for extended durations.
Right. And you're allowed to have somewhat similar screening process for care providers because they're going to be living in the property. There's different HUD requirements and income requirement, like if when Section 8 is calculating rents, like the caregiver, anything the caregiver's making doesn't count towards household income. Like there's some various rules, but you are allowed to collect sort of the basic information on that person, who they are, run their background checks to make sure that, they would qualify. You're not going to be looking at income stuff because their income doesn't come into play. But you can definitely screen them, do your standard other checks that aren't related to credit or money, um, to vet them. So,
And with that too, we have one more question, Sandy. Thank you very much. Keep them coming. What if it's an online certificate someone bought online for $25? I'm assuming
yep.
she's referring to either the ASA or the care provider.
Yep. Well, no, you can actually go online and buy a certificate that your animal is a certified ESA or certified service animal. That doesn't meet the legal standard. Because it's not something indicating the person has a disability, that the animal is necessary for their disability. That's focused on, we've registered this animal. So that's different, and that does not meet the legal standard. So I have a couple of tools and I put them up as QR codes because I figured people were going to be watching and could may be interested in snapping this as a picture. So HUD, Housing and Urban Development, has a lot of great resources on fair housing, among other things. This HUD interactive tool, if you walk your way through it, it actually takes you through a series of questions if you're processing like a request for ESA. So it's like, it helps you like navigate to get to an answer. It's actually a pretty cool resource. So I thought that I would throw this up here if people wanted to take a look at it and walk through it and see the information that sort of HUD's providing on this. And the other thing I wanted to put up here is a webinar that HUD had done specifically relating to ESAs and ESA approvals. And, the reason why HUD's such a great resource is that's where HUD does enforcement for housing enforcement in Vermont. And, so if you're getting information from the agency who's doing the testing or doing the enforcement, you're getting the information that the regulators sort of want you to have and want you to follow, and so thought I would put those up there for folks because they're pretty good. All right, so moving on to VAWA. So VAWA is the Violence Against Women Act. I think the title of this federal law creates some challenges. So VAWA actually applies to all genders. So it's not just specific to women, even though it's called the Violence Against Women Act. But it doesn't cover all tenants in Vermont. So the federal law covers federally subsidized programs. So your Section 8 tenants, folks who are receiving some sort of federal subsidy are covered under the VAWA law. It does not apply to market rate units. So there's sort of, you may not be impacted by VAWA if you don't have Section 8 or subsidized units. HUD has definitely sort of stepped up some of their enforcement in this area. They are looking at this and taking complaints on this in Vermont. So if you rent to subsidized units, like this is something that you want to be aware of, because there's some additional requirements and things that you have to follow when you're renting units, and also at the time you're asking people to leave. And I'll get to that. I'll show you there's a federal form that you might see occasionally. And so if you see one of those forms, I think, it should raise a flag for you that you need to maybe ask some more questions or connect with your attorney before making final decisions. Vermont itself also has a domestic violence statute that relates to housing. And so this one, the Vermont one, is definitely much broader. It applies to a quote protected tenant. And so that's somebody who's a victim of abuse, sexual assault, or stalking. And it's also the custodial parent of sort of a minor, if the minor is the person that is the victim. And the kinds of protections that the Vermont law allows, it allows people to break leases if they are fall within this category. It allows lock changes. It allows for the tenant to request additional security measures that the tenant would install. But it would allow for things like installation of security cameras or other things. And it also has a confidentiality component. The Vermont law is generally self-certifying. So it means the tenant can self-certify that they fit into this category. And the law also provides protections to a landlord who takes actions based on that self-certification, particularly as, lock change requests is generally one of those things that I'm like, danger, danger. But this is, that's accounted for within the law for this particular group of people. So. And so where are we going to see this VAWA situation come up at an application phase? So if an applicant comes in and presents you with this form, so this is a fancy form that HUD put together, and on the next slide I'll show you what that form looks like. So if they bring you this form that says, I'm a victim, here's the details of how I'm a victim of domestic violence, one of the components of or that happens to people who are in this situation is actually financial. And so there can actually be financial abuse in a relationship where one partner has taken out credit cards or debt in the other partner's name, sometimes with or without their knowledge. There's also a lot of times restricting access to work and employment, so restricting access to income, which can create a lot of challenges for somebody as they're trying to move on. So, where this can impact you as a landlord is if you're renting a unit and somebody comes in and they have one of these forms, and on that form they say one of the ways my partner abused me was credit, and I have bad credit because you're most likely going to be in a position of having to exclude any of your credit criteria for that person as you're looking at their application, because the credit problem is tied to this status as a victim of domestic violence. So it gets complicated very quickly. So I'm more just sort of raising these as like, hey, if you see this form and you have somebody applying with this form, you might need to look a little harder, or you may need to reach out and have a conversation with somebody before just denying them based on credit or your other criteria. It can also be something like if there were a lot of complaints for noise or, police being called or things to the unit, if that was related again to that domestic violence situation, you may have to pretend that didn't exist as you're processing these applications for this particular category of applicants.
Angela,
Yeah.
two questions. One from Abigail. Thank you very much for your question. When or with the lock change request and security measures,
Mm-hmm.
does the landlord have to pay for that? My hip answer
No.
would be no,
No.
but also would you encourage us to make the changes if they were unable to do it and potentially seek it out of their damaged
For,
security
yeah,
deposit.
for lock change, yes. I think for security measures, unless it was something you were planning on doing anyway, or,
Mhm.
adding to your property, no. Right. So both of them are at the cost of the person that's requesting them. But like with anything, sometimes it makes sense for the landlord to take that on. I know a lot of landlords, if they get a request for the installation of something like a grab bar in a bathroom, will just go ahead and take care of that
Yeah.
and not charge the tenant for it. So it really sort of depends. Um,
Just the property management idea for anybody who's got multiple units or buildings, having a master key system is an amazing thing because then
yep,
you can keep an extra lock around that is keyed to your master keys.
yep,
So you can swap out locks quickly, but not do it in a way that screws up your
right,
whole master key
right.
system.
Well, and some are going to like electronic locks. So
Love
so
electronic
it's
locks.
coded access, so there's not even a key.
Yep, love
Um,
those.
Uh, I I added this applicant provides a court document. So while forms are great, and I think they present, a way for you to flag things internally, with so many of these, there's no requirement that somebody use that actual form to receive the protections under the law. So, an applicant could come to you with a relief from abuse order from a court or some other sort of court document that lays out, the same things that this HUD form would have. And that's just as good as if the person brought you that HUD form. So, don't be like, oh, well, it's not on the form, I don't have to consider
Mhm.
this. The information may come at you in different ways. And it could also be that through the course of the application, they, provide you with enough information that it appears that maybe they do qualify under the status. And if that's the case, you may want to consider giving them that HUD form to say, I'm just going to provide this to you. If you want to use it, it's fine, or you think it applies to you, that's fine. But, again, tenants or applicants usually don't use sort of the magic words that we're talking about, even if they're making like an ESA request or an accommodation request. They're not going to come to you and be like, I'd like a reasonable accommodation. They're going to use other language to describe what they're asking for most of the time. Um, so this is that HUD form, that 5382, that somebody can fill out, and you might start to see it out there. It's also one of the forms that if you have a Section 8 tenant and you're sending them termination notices, that you needs to be included in with their termination notice. There's a whole other packet of information too. So if you need that, it's on the Landlords Association website, but you can also find it through HUD as well.
And this is relatively newer stuff. Is this a couple years old, or because
So the Violence Against Women Act was reauthorized in October of 2022. So it had been in existence previously, and then the law sunset, and then it took a number of years for Congress to reauthorize it. When they reauthorized it, they added some new sections like the financial credit, and financial abuse is relatively new. And so, yes, this is sort of new as of about 18 or so months ago. Yep. And then if you would like some more information on this topic, that will take you to the HUD sort of landing page for violence against women. There's a lot of good resources. The forms are up there. I think there's some education modules. There's some flyers and pamphlets that HUD has sort of put together. They really have sort of stepped up their game with educational materials for folks, and have a pretty comprehensive website on for a lot of these different fair housing topics out there. So, do we have more questions? I think I was anticipating more like ESA related questions, or, I guess going back to reasonable accommodation requests, I did mention parking's another one that I see a lot of requests for. So types of requests related to parking. If you don't have assigned parking in a lot, you could have somebody with mobility challenges asking to have an assigned parking space for them. Um, unless there's a very good reason or the lot doesn't allow it, those requests should almost always be granted. They're pretty straightforward. They are an easy accommodation. And although, other tenants get mad, it's like, you're following fair housing rules. So that's a common one that we see. Sometimes you'll see them with a request if there's assigned parking to move someplace closer or to have, a specific spot that makes it easier for the person to access the building. Again, that's something that, should be considered, and unless there's a really good reason, granted. So,
Go one more question.
sure.
Is there a limit to the number of ESAs an individual can have? And is there there's a number of service animals? Now, I heard one, and I don't know if it's a unfortunate urban, story from Vermont, but I heard of one, that BHA, again, this is all secondhand, had somebody who had something like 12 or 13 rabbits.
Yeah.
And when they were challenged, or the landlord challenged them, if the rumor mill's true, they had an attorney who listed 11 special needs or considerations, each one warranting a separate service animal,
Yep.
in this case, supposedly a bunny.
Yep. So correct. I mean, I haven't heard of that story, but that is a sort of extreme illustration. The answer is no. There are no guidelines or restrictions on the number of ESAs. Only that each ESA would have to be for a different reason or a different disability, different symptom of the disability. So yes, it would be possible for somebody to have more than one ESA for themselves or an ESA for all members of the household. So no, there's no guidelines at this point or restrictions on number of ESAs.
And that's where, if I had any advice for anybody, if they get somebody they feel like they're playing game, maybe they're not. I'm hard pressed to think of 11 reasons to have 11 bunnies, except if you have a smoker, and that's a politically incorrect joke. But that being said, if somebody is playing that type of tactic, I guess playing is not the right word, then I would just encourage people not to dive into questioning it too hard, but finding other ways to have a diplomatic resolution to it, so that people just don't get pitted in. I'm going to show this person, they're going to show you, because it's that
Right.
escalation goes
Right.
nowhere good.
Trying to prove your right in a fair housing context can be harder and more aggravating than sometimes finding the solution that is not fighting that battle.
And there's a great question. Do you want to be
Yeah.
right, or do you want to, an opportunity to retake that unit and find a more appropriate
Right.
fit? One more question. VAWA is only sent to people in housing, or do we send it to anyone that we suspect may fall under this protected class? And I think this is in reference. I was under the impression if they're on federal subsidies and we're sending out non-payment of rent or other evictions, we had to include the VAWA documents.
Correct. So if you have a tenant that's receiving Section 8 or has another federal rent subsidy, the VAWA documents need to be included in any termination notice that you're sending out, regardless of what the household composition is. So this is where the name of the law creates a little bit of a misnomer. So any tenant that's subsidized, regardless of who they are or what their gender is or what their household composition is, would need to have those VAWA documents included in that termination notice.
But if they're not, if they're not getting any type of federal assistance,
Then nope.
we don't have to send it.
Nope.
All right. So then, Abigail, thank you for the questions too. Always love to have them. But what if they're a current tenant, you're not sending them a termination letter?
Then unless they've requested that form or have somehow given you information that would suggest that they might need that form. If they're a current tenant and they're having some sort of challenge, I might actually suggest the Vermont certification form, because it actually is a little bit more practical with like, this is what the form actually says, this is what I'm asking you to do. And it's like a checkbox of the various things that would apply under the Vermont law. So, if you're not in sort of an eviction setting, but you have somebody who may be able, may qualify under that domestic violence or abuse or stalking sort of situation, the Vermont self-certification form might be the one that would be more appropriate to be like, I just want to give this to you as so you have another option. You do have to be a little bit careful when you're dealing with folks who may be victims of domestic violence, depending on, is it a household partner? Is it not a household partner? That can kind of create some dangerous situations for them if they're living with that person. And these issues are still going on that can be really challenging for them to access help that doesn't put their own personal safety um, on the line. So it's a very complicated and hard situation, or can be, to manage for everybody.
Abigail, great questions. Dora, thank you for yours as well. Angela, it's 1 o'clock.
Yes.
Fair housing is flying by. We got actually
Fair
one
housing.
more question.
Okay, go.
On a different topic, do you have a source for doing criminal background checks on an applicant over and above doing a credit check? In-state,
So,
out-of-state, peers, landlords need to go
yep,
over above and beyond
yep.
to do due diligence.
So for Vermont, the only place to get criminal records is from Department of Corrections. So the Vermont Criminal Information System. So if you Google VCIC, VCIC will take you to the place where you can request criminal records for Vermont. It also has the sex offender registry, and that's the only place to get them for Vermont. Other states participate and provide those records to background check services. So I think it would depend on where the person's coming from, whether their state would be covered under one of those more national background check type programs. Vermont does not participate in those. So VCIC is the only place to get those for folks living in Vermont. And I believe the charge is $30 currently per records request. So
sounds like $30 worth of great prevention. We had one time, we did one, nobody disclosed, the guy had a pipe bomb, conviction for being in high school. So I'd say, Sandy, you're great to ask that question. And I would absolutely encourage anybody dive into that stuff. It's absolutely essential.
Google's also a good place. There's a lot of stuff that you can find, newspaper articles and otherwise, just by using Google as well.
Well, they tie it up too. It's all about a system, Google, social media, credit, background, reference, and did you follow it with each one? And if you type up that system, if you ever question on fair housing, you'll have a system as opposed to
And this is what I did every time for every person that applied. So,
And with that being said, we appreciate everyone being here. Angela, I've grown at least 3 ways today. We're going to start looking at virtual tours. Oh, shoot, now I'm forgetting the other one. But really appreciate the information, the VAWA information, which is a newer thing that I think some of our members are getting used to. And folks, I can't stress enough, first and foremost, thanks to Angela for all she's doing for advocating for us. And again, I'm Brian with Strongwell Property Management, KW Vermont, and Strongwell Real Estate Team at KW. Stay grateful. And I think, keep looking out for
and next month we're going to be in person at Brian's office facility there in South Burlington, and we have somebody coming in that's going to talk about solar, EV chargers, and whole house system battery systems. So
great way to look for some tax deductions as well as attract even more residents.
Exactly.
Folks, have a great day, and thank you very much for the time today. Angela, thank you as always.
Yes, thank you. See you next month.
Take care.